Welcome to Feminist Question Time, brought to you by Women's Declaration International, the leading global organisation defending women's sex-based rights against the threats posed by gender identity ideology. Congratulations to you all getting here to this webinar. It's amazing to see you. Well, not that you're all here to see the numbers piling up. We are almost all radical feminists here, so possibly the epitome of TERFs. We have been RadFem since 1970s, and our analysis of gender identity ideology has been consistent since then, so for 50 years. We were not surprised when it came along and have not changed our analysis. In 2018, we wrote the Declaration on Women's Sex-Based Rights, which lays out our position, which has now been signed by 38,301 people from over 160 countries and is supported by 531 organisations. We have volunteer activists, including country contacts from every continent. Please join us. You can also become a member of WDI to help our work by volunteering or donating. You can email in to info@womensdeclaration.com, or you can go onto our website, which is womensdeclaration.com, where you'll find all the information there. So we have Sheila Jeffries, who will be talking about the time of the Gender Recognition Act and what was happening then. It's 2004. And then we have Julia Long, who will be talking about the activism that was occurring after that time. And then we have Maureen and Tracy, who will be talking about what we at WDI propose moving forward after 20 years of having this in place.
Now, the Act was introduced by a Labour government, and at the time that the Act was created, the feminist movement had had a serious backlash, and it was fairly inactive. So no one was pointing out that the Act was a problem at that time. I was in Australia and I didn't find out about the Act until after it was passed. I then researched and wrote an article criticising the Act, which was published in 2008. I couldn't find any criticism of the Act at all to mention in my article, so I had to work it out myself. Now, the Act was the result of the activism of trans rights campaigners. It resulted from a dramatic change in the understanding and terminology that was applied to men who were masochistically excited by pretending to be members of the underclass of women in the 1990s. Before the 1990s, men's cross-dressing behaviour was understood as a sexual perversion by sexologists, the scientists of sex, and it was called transvestism. It was an occasional practice carried out by men on weekends away and at special clubs. These transvestites did not pretend to actually be women. They were hobbyists. They didn't take drugs or have amputations, and they didn't have political demands at that time. A very small number of men who claimed to actually be women were called transsexuals, and these men were subjected to drugs and surgery. Some of them were simply transvestites who went too far, got carried away, one might say, and others were unhappy homosexuals who wanted to have relationships with men who saw themselves as straight, and if possible, to marry so that they could imitate heterosexual couples. There were some women, but very few, who sought to be transsexuals at that time, but for very, very different reasons, and usually because they were unhappy lesbians. In the 1990s, a movement of trans rights activists developed, which was fueled by queer theory and the sex industry. Queer theory argued that something called gender could be changed at will, and that such flip-flopping was transgressive. The understanding that transvestism was a sexual perversion was a hindrance to these transvestites. These new activists wanted to get rid of the stigma of being sexual perverts, so they created the idea that they were not sexually motivated, but in fact possessed of something called a gender identity. They claimed to be a special kind of person and demanded rights to what they called gender expression. This sounded better than a sexual perversion and would allow them to demand that their impersonation of women must be sexually accepted and perhaps even celebrated. The men's rights movement, that is transgender activism, is not a social movement in the sense that this is usually understood. It did not progress by educating the citizenry, as is the case with movements to establish women's rights, such as the rights to abortion, or disability rights, or gay rights, or the rights of ethnic minorities. As a general rule, public opinion is changed by public education over years to the point at which legislation is brought into line with a new understanding, such as happened with gay marriage. The legislation to pretend that men can become women, on the other hand, seems to have received little publicity. A cross-party parliamentary forum on transsexualism was set up in 1994 in the UK, and work began between politicians and campaigners to promote the practice. This is the behind-the-scenes way in which this legislation, which the public, after all, was likely to reject, has been pushed through in most countries. So it happened quietly within Parliament and behind the scenes. Now, in order to get the legislation through, an understanding was created that transvestites were a minority, a special rights-bearing group of people who needed to be protected. But in fact, of course, this was an invented minority. It's actually, there's no such thing as a transsexual. The Labour government of the time said it was required to introduce the legislation in order to bring the UK into accordance with European human rights law. But creating a law which is absurd and based upon a lie could surely have been avoided. The legislation at the time was seen, and the campaigners all say now, it was the most progressive in the world, and the government prided themselves upon it. But other countries were not rushing at that time to pass this legislation. Now, this is the preamble to the Gender Recognition Act, which was introduced in the House of Lords, not the House of Commons. And this is how the government introduced it. They said, the Gender Recognition Bill is a part of the government's commitment to reforming the Constitution so that it better meets the needs of all people. It also reflects our commitment to social inclusion. It is essential that no one is left behind as we create the conditions for a credible and effective modern democracy. So there you are. This bill was necessary to modern democracy. There is a strong tradition of legislation in this country that has sought to respond to the concerns and needs of minority groups, whether these be ethnic minorities, people who are disabled, or now, with this bill, transsexual people. It's interesting that it says transsexual there, not transgender, of course. I believe that this is a reformist tradition of which we can be proud, although, of course, it leaves out women. But the idea that transsexuals are just ordinary, respectable minorities, transvestites rather, that like gay men, is very problematic. In fact, of course, transvestites are motivated to imitate women, men who see themselves as transvestites, transsexuals, and so on, by sexual masochism. And there are many other men's sexual perversions which are similarly motivated. So I think it's worth asking, would the government think it necessary in this grand reforming tradition, in order to support democracy, to create legislation to recognize and protect men who have other sexually masochistic perversions? It does seem unlikely that any government would want to pass legislation entitling these other groups of men to protection of the expression of their masochistic fantasies. Many men, for instance, are interested in age regression. Men from the ABDL, adult baby diaper lover community, would like more acceptance of their interest and protection in law. In just one example of the suppression of their rights, as they would probably see it, in 2022, a woman went to the family court to get her ex-male partner excluded from access to his children because he was getting more deeply involved in his perversion, and collected the children from his partner with his nappy partly on view, although he had an agreement with her that he would keep his interest hidden. She said this constituted a risk to the children, and she won that case. Now, the government is unlikely, I would think, to think that they should extend him protection, although this is a very, very similar perversion to transvestism. I wrote in my 2022 book, Penal Imperialism, about cases in which men demanded that women change their dirty nappies, something that gives these men exquisite sexual excitement. The women sexually harassed in this way have included university lecturers and carers. So it could be that these men would like to be able to enforce the nappy changing on the women they come into contact with in these ways, and the government could pass legislation to say that women actually must change these nappies. Now, a man's baby identity is not yet respected in the law, even though it would be a female baby identity because their baby identities are always female. It's a variety of transvestism, transgenderism. Other masochistic fantasy identities are not protected either, such as those that feature disability, the practice of getting surgeons to cut off the healthy legs of male practitioners of apotemnophilia, or sexual excitement from the amputation of limbs, and not just penises, as sometimes is the case in transgenderism, was stopped in the UK in 2000. So that was actually stopped taking off legs. Masochistic perversions that feature the imitation of race for sexual purposes are not protected by law, and I don't see them being soon protected by law. In fact, the protection of men's sexual perversions in law inevitably damages the human rights of those categories of actually disadvantaged person that the men are imitating for their pleasures. The rights of women, the disabled, ethnic minorities, children are harmed by the demands of these white able-bodied men that they should be included in these groups for the purposes of their erections. The politics of equality, as we have always understood them, are made absurd and unworkable by the demands of the male sex right. Under the 2004 Act, a person may apply for recognition of their acquired gender by appearing before a panel which will decide whether to recognize them or not. The panel must grant the application if the following conditions are met by the applicant. They must have or have had gender dysphoria, have performed what is usually called the real-life test, i.e. lived in the acquired gender throughout the period of 2 years, ending with the date on which the application is made, and intend to continue to live in the acquired gender until death. I mean, all of these things are very absurd, of course. The idea that anyone can promise never to change their minds about something which is entirely fantastic, in other words, a temporary state of mind, is absurd, and just one way in which the legislation is unworkable, because there would need to be facilities for men to be popping in and out. Of course, that would be changed with self-ID. I guess they can just pop in and out of the office day by day. As we know, there are, of course, many detransitioners, and so people change their minds about this all the time. The applicant must provide evidence of their acquired gender in the form of either a report made by a registered medical practitioner practicing in the field of gender dysphoria, and a report made by another registered medical practitioner, or a report made by a chartered psychologist practicing in that field, and a report made by a registered general practitioner. The legislation does not require that applicants should have undergone medical treatment in the form of hormones or surgery, and that's one of the ways in which this legislation was seen as tremendously progressive at the time. There's no definition in the Act of what gender means, unfortunately. In fact, there is, as we shall see, profound confusion. The Gender Recognition Panel has to exercise their own preconception of correct gender behavior, advised, of course, by the practitioners. And I don't know if a man retains his beard, for instance, as many do, and makes no attempt to look like whatever they think of feminine gender is, would they be rejected by the panel? And apparently some are rejected, but I don't know if it's for that reason. Or would a man shave for the occasion and wear a skirt just so he can pass the recognition test? Apparently they do get, or did get, advised about what to say. So they do get some training, and it might say shave beard and that kind of thing. Now, so in terms of the definition of gender and what creates it, the civil servants and the politicians who created the legislation did not believe that gender was biological, as so many politicians seem to believe now. A consultation was held on how to meet the demands for gender rights in legislation, and this reported, it was set up by the Home Office and it reported in 2000. A call was sent out for submissions to physicians who specialized in the area and in effect proselytized for the campaigners. And a call was sent out to pressure groups that have been set up to promote the practice, 7 of those in the UK. The Act is very much the child of an international movement of transgender activists represented in the UK by organisations such as Press for Change, the Gender Trust, the FTM Network. The 2 main campaigners from Press for Change were a man called Christine Burns and a lesbian who calls herself Stephen Whittle. And they were awarded an MBE and an OBE, these are honours, respectively, for their campaigning efforts for transgender rights and towards the GRA. It did not occur to the Home Office, who set up this consultation, that they should consult women's organisations, or that a law letting men officially imitate women could affect women in any way that mattered. It did not occur that an impact statement was needed. There was nothing about what this massive change could actually do. And they did not accept, though some of the submissions did say this, that it was biological. Some of the physicians said it was biological, but the committee that reported did not say so. The report states, the cause of the condition remains obscure. It states sensibly that gender reassignment is commonly termed a sex change, but in reality, it is an alteration only in a person's physical characteristics. The biological sex of an individual is determined by their chromosomes, which cannot be changed. That's tremendously sensible. And of course, nobody's really allowed to say that now. It's become a rather dangerous thing to say. So by the time the Act was introduced into Parliament, though, it was mired in confusion. To look at what the Home Office explains, this is 2018, in an explainer, they're saying what they say that gender actually means is very, very different from the understanding at the time. So the government has attempted to define gender more recently. This says gender is either of the 2 sexes, male or female. And it didn't mean that in 2000, and it's clearly, of course, extremely wrong. So somebody has changed the meaning, and the explainer helpfully gives a definition of non-binary too, which was not invented in 2004. Non-binary didn't exist. It says non-binary means that you are neither a man nor a woman. Since all humans are either men or women, this suggests that there is a category of non-humans, which are potentially werewolves. So things have gone very crazy and very different since 2004. I just want to give you a little idea of what was said in the House of Lords, because the debate is wonderful from the time. And the Tories in the debate are just splendid. They just aren't having any of it. And they say all sorts of things that nobody would be allowed to say today without getting a knock on the door from the police and so on. So this is Lord Tevitt, a conservative, very conservative peer, and he was once a minister in the Thatcher government, and he says quite sensibly, there is a major defect in the bill in its confusion over sex and gender. Is the bill about a change of sex or a change of gender? And then he says, sex cannot be changed. It's no good the minister shaking his head. You can imagine this going on in the chamber. Sex is decided by the chromosomes of a human being. If we have XX chromosomes, we are women. If we have XY chromosomes, we're men. As far as I know, there is no law or any known medical procedure that can change the sex of a human being. The bill purports to do so. It is therefore an objectionable farce. Nice language, I think. The extent of the confusion over sex and gender on the government side is revealed in contributions by Lord Filkin. He's speaking for the Labour government at the time. He says vaguely, the word sex now has more of a social and psychological connotation that it would have had 20 or 30 years ago. I don't think so. He's sort of lost biology. He's sort of forgotten biology. Then he compounds the confusion by saying the bill is about legal recognition and it will define a person's sex in law. We consider the argument about the meaning of the words sex and gender to be beside the point. There is no stark dichotomy between the meaning of the words. So in other words, complete confusion. This is he's there to explain the bill. Right? There is no definition of gender and there's total confusion. I like her best. She's absolutely wonderful in the debate, absolutely splendid. She's still alive, I think. We should really go and see her. I don't know what she's saying now. She says, a large body of research and experience composed among others or members of the medical profession maintains that the condition is a delusion, a fantasy. The problem is psychological, not physical. Psychologists agree that. For decades, gender dysphoria has been well known as a psychological condition. There's no evidence for changing that view, apart from a form of political correctness. Political correctness is now called, I think, wokeness. But it's wonderful that she was saying this back in 2003. It's absolutely splendid stuff. So many issues that were brought up by the Conservative critics at the time spoke to the wide impact that the change in the law would have. And they spoke of the problems with sport, of course, and they were poo-pooed. So it's not until more than a decade later that the problems they spoke of, and they called cheating, turned out to be just as they had foretold. And we, as feminists, had to create huge campaigns against it.
Our next guest today is Julia Long. Everyone who was kind of arguing the point, who'd actually looked into it, could see all the problems. So what happened then on the ground, Julia?
Okay, so yeah, that was absolutely brilliant getting that history, and just reminding Sheila, just reminding us there of the clarity of some of those contributions to the debate at the time, which is a clarity that has been really very much lacking, even from the some quarters of the so-called like gender critical movement. They haven't necessarily been as clear as some of those early politicians were. And in fact, just as Sheila was talking, I reached behind me. This is going back a little bit further. I reached behind me for to my I've got a thing to blow my screen, but anyway, it's my to my Oxford English Dictionary, which dates back to 1991, that version, and it's just really helpful, I think, to remember a time when that word transgender, it just actually didn't exist. It wasn't even present in the dictionary. Like, this dictionary goes from transfuse to transgenic. The word transgender didn't even exist. If the word transsexual is in there, but it's got quite a nice definition of something like, the physical attributes of one sex and the supposed psychological attributes of another. So whoever wrote that You know, I think they kind of knew what time of day it was as well. So I think that's one of the things that is really very frightening about what's happened, is that for, you know, a generation, or probably coming up now, even getting on for maybe a couple of generations of children, will be growing up thinking that there is this thing called transgenderism, and there are people who are trans, and that's it. That is part of their worldview. And I think that's why so many of us, who obviously some of us were very kind of mobilized and politicized around this a long time ago. But, you know, I think it's not surprising that a lot of the women who are very much involved, not universally, but a lot of the women who are involved now in opposing it, just remember a time when it actually didn't exist, you know, that we didn't have it, and there weren't all these children, you know, desperately, you know, suicidal because they wanted to, you know, cut parts of their body off and all this kind of thing. Anyway, sorry, I just went back to just sort of just indulge myself in that little trip down memory lane to a time before it all, before me does now. I would say for me personally, I wasn't living here either. I was in Ireland at the time, and I honestly can't remember how aware I was of this, the GRA. I don't. I'm ashamed to say that I think if I was in any way aware, I just thought it was a very obscure, marginal thing. I honestly can't remember. This is me kind of supposing now. But when my eyes were really open to it, and as usual, I really have to credit Sheila with this. It was in 2006 when I'd come over. I was planning to move back from Ireland then, and I'd come over for Sheila will remember this, the Andrea Dworkin Memorial Conference at Oxford University, the year after Andrea Dworkin had died, and Sheila was speaking at it. But as I remember, Sheila can correct me afterwards. As I remember, the presentation was mainly about beauty practices. That's my recollection of it, and particularly looking at Andrea Dworkin's book Woman Hating. But Sheila did then also talk about some of the. I remember her talking about, you know, Norman Tebbett's contribution, and talking about this debate, and that was, I suppose, that was really my wake up moment to like what had happened and what had been allowed to happen, and what and to just start to begin to get a sense of the implications of all of that. So that was really my wake up moment. And then I suppose
what year was that? Sorry, Julie.
So that was 2006. So that was a couple of years after the GRA had passed. And then I did move back to London, and like this is obviously just my own sort of personal involvement. I was very much involved when I came back to London. I was very much involved with anti-pornography activism and sort of broader anti-sex industry and anti-sex industry sort of activism, feminist activism. And I suppose when I really became directly involved was when Sheila and I, and there were various other women involved, were organising RadFem 2012. And I think that's a really important era for women to be aware of. And I remember I'd met Sheila just the year before, and we were both in complete agreement of how necessary it was to have women-only spaces again, and women-only events, and women-only organising. And I suppose at the time I was coming from it, from an experience of this kind of new generation of maybe not liberal feminists, because they were anti-porn, anti-prostitution, but they were very inflected by some of the norms of liberal feminism that had kind of, you know, come to dominate. And one of the things that a lot of them believed was that, oh, we have to involve men in our activism because the logic, the so-called inverted commas logic, was that, oh, because if we want society to change, men are half the population, so we have to involve them with everything, otherwise society is not going to change. That was the kind of attitude, and it's really quite difficult to convince them otherwise. And I just spent several years getting really so angry and frustrated, and I just felt we really need to have a women only some kind of event to get us back onto a more radical feminist analysis and sort of pathway. So that's when we had the idea of doing RadFem 2012. That was going to be the first absolutely uncompromisingly unequivocally women only event for a long time. I don't know when the last thing, I think it probably been for a good sort of 20, 25 years since that sort of thing had happened in that public way. Anyway, I'll try and be quick with it. I did write, I wrote a piece for Female Erasure, which is a really important book that came out in 2016. I did write about this in Female Erasure. But anyway, I just remember it was a pretty stressful time for me because I started a really responsible job and I was moving house all at the same time. I was doing this conference, and we put the website up saying that it was women only. It went up, the conference was due in the July, and we put the website up in the May, about the middle of May. And then, I don't know, I went to bed, and then I woke up the next morning to this like absolute kind of pandemonium that some awful trans activists in America, someone had put it on Twitter, it had been picked up. And then we were just, that was the beginning of being absolutely besieged by all of these terrible trans activists and handmaidens that were just going to do their absolute damnedest to try and stop us having that. And I think that event was really such a wake-up call for a lot of women to see that, you know, and we've seen it since now. You know, you go to a Let Women Speak event and you get all this, you know, you fascist, Nazi, you know, all of that kind of stuff. And that's what we got. It was a hate rally. It was a Nazi hate festival. And the thing was then, you know, now there is obviously quite a considerable movement, but at the time, pretty much everyone was either against us or just completely silent about it. So at the time, there were these so-called like sort of new voices in feminism, like Laura Bates. I don't know if you remember. I don't really hear so much of her now. She had a book called Everyday Sexism. You know, there were all these kind of women all posting about how this was terrible. We should be ashamed. It shouldn't go ahead. And this this really awful man called Ros Caveney, who was one of the main sort of ones who were definitely out to sabotage the event. He went to our venue and said that it shouldn't go ahead, and he was very, very exercised about not wanting Sheila to speak, because this man was very much from the kind of older, and I don't know, 1980s. He was like this awful, like pro BDSM, pro sex work, awful man in a dress who had a massive grudge against Sheila in particular, because she actually had, you know, very clearly and, you know, rightly stood up to challenge him. So he was determined that we wouldn't have our event, and he wrote this really vicious piece for The Guardian, which I remember then Sheila did write a response to. He was, you know, but the other interesting thing about, because we were supposed to have the event in Conway Hall, and Conway Hall had hosted all kinds of events. You know, they really sort of prided themselves on being this, you know, very open, free speech kind of, you know, they didn't use the term at the time, but, you know, in inverted commas, inclusive venue. They'd had like the IRA. I believe they'd actually even had PI, you know, the paedophile information. I think we even found sort of, you know, images of that. So they had all of that. And then, you know, a group of women wanting to talk about male violence and prostitution and, you know, all the things that we were going to talk about, we had to not be allowed to have it. And it was really interesting to see, like, you know, some of the prominent feminists, well, a couple of the prominent feminists who were going to speak at that pulled out. Gail Dines still spoke at it. And, you know, the event went ahead, but we had to go to a secret venue because it was just too dangerous Conway Hall pulled out. And then
they did host other events after, didn't they?
They did subsequently. Yeah, they did subsequently.
Okay.
What I was going to say was, it was actually the chair of it was this, oh God, pretty unpleasant character. Again, like, it just exposes all the politics. A humanist. He was I think it was the chair of the British Humanist. His name's something like Andrew Mawson or Hobson, and someone in the chat might know. Anyway, he was absolutely determined it wouldn't go ahead. And to be honest, we were on a quite tight time frame. We just went to a secret venue, and there were some very, very prominent, still very prominent feminists now who really disagreed with us about that. And I got some pretty unpleasant emails about how I was destroying radical feminism, by making us, look kind of, secretive and all the rest of it. We looked like we were the BNP, but obviously it was something that we had to do, because if we'd gone public with the next venue, the same thing would have happened. And it's interesting how that has been something that has happened routinely now since sort of 2017, 2018, with groups not making the venue public. But I think because we were the first ones, to my knowledge, that happened to, a lot of women weren't with us. So I'm just so grateful for those women who were very involved at the time. And the event did go ahead. We had about 150 women, which was really something. Yeah. And then Sheila, in particular, I remember on the second day, it just did this barnstorming, like this fantastic speech, because there was a lot of woolly thinking about it, a lot of uncertainty. Women really didn't know what to think about it. And I just remember that event, I just felt everyone, well, not everyone, a lot of the women there sort of started off over here. And then by the end of the weekend, they were over here and they really had clarity about it. I've probably used up all my time talking about that.
Yeah.
Anyway.
No, you're fine. I haven't
got 5 minutes.
Really, yeah. I think we've got a bit more time. But so is there videos of that? Or was that before all this time?
That's so frustrating. Someone did film the whole thing, and then she never let me she said there was a problem with it, and she never I was never able to get the video. It was kind of in the early days before things were routinely filmed. So we made sure that we had the Thinking Differently conference, which in a way was 4 years later, was in a way the kind of follow-up event, but that focused absolutely on like a feminist analysis of transgenderism. And that actually, that was held at Conway Hall, because I think by then they had a different, they certainly had a very helpful woman. I won't mention her name. I don't know if she'd want to be mentioned, but she was very helpful, and she was on the board there, and she was determined that they would, make amends for what had happened before. And we gave it this very innocuous title of Thinking Differently. And we were perfectly public about it. And for some reason, we didn't get that kind of, we weren't besieged and attacked in the way that we had been before, and that other things had been after. So those really powerful presentations, including Sheila, Mary Lou Singleton, Leah Keith, Stephanie Davis-Arai, because Transgender Trend had got going by then. There are a lot of really excellent presentations. They're all on YouTube. They're on actually my old YouTube channel that I don't really use now.
I found your YouTube channel.
It's still up there. So that, and I really would like to put on the map that was the first ever feminist conference devoted to an analysis of the politics of transgenderism. I'm really so very sort of happy and proud that we did that, especially having had that earlier experience. But what I should maybe briefly say is that time, I think it would be really good to do some historical work on that, because that time of 2012, it was the era of a lot of radical feminist blogs that we don't really see now. That era is not really around anymore. But there was the amazing Gallus Mag, who did Gender Trender. Again, very, very forthright, far more forthright than a lot of those involved now. She didn't go along with all this kind of nicey, softly approach at all. There was Radfem Hub. There were a lot of different Radfem blogs, and there were a lot of different radical feminist conferences as well that was similarly attacked. There was, there were several in the US. There were, I don't know, at least a couple in Australia. So, and there were more here as well from like 2013, 2014, 2015, there were more going on here. And that was a really important time that again, anything that was women only would just be absolutely attacked, not only by all these awful men and their handmaidens, but kind of more broadly by a lot of supposedly feminist groups as well. Really awful. And that preceded even the event organized by, that was an era that led up to the 2016 Thinking Differently conference, and we'd had a couple of other actions which I could talk about, but run out of time. And then obviously 2017 was when Venice Allen and a couple of her sort of associates, who again might not be appropriate to mention, but it wasn't just Venice, it was the three of them organising it. They organised the event at the Women's University Library, obviously then, where we had to meet at Hyde Park, and where at least two men assaulted Maria McLachlan, and one of them at least went to trial for that. And then I think it was later that same year that there was the first Women's Place UK event, and then over from sort of 2018 you started to get more of these real life events, but they were all really besieged, both the ones that Venice, and then I think Venice and Kelly J organised, and the Women's Place UK, and some other groups as well.
But they kind of came out of the Gender Recognition Act consultation, didn't they? That was 2018,
well,
and that's when they kind of
but
kicked
they'd
off.
started. No, yeah. They'd started before that, because that was kind of I don't know, spring summer of 2018, and obviously the Women's University Library, Venice's one, that was 2017.
No, I mean the Women's Place UK.
No, Women's Place UK started late 2017 as well, around about October, I think it was. Yeah,
right.
And I know at least one member of Women's Place UK had come to thinking differently, and also things have been happening online. I mean, there's so much to say about this, but actually we really should do some more work, those of us who are around then, to document it, because obviously there's been a lot going on Mumsnet, and then some of those groups started up Facebook groups. I'm not so aware. There'd be other women who could say more about what was happening on Twitter, but there were groups around, like the Fair Play for Women, that started off as very much focused around sport. That was all happening before the consultation, but then I guess really got going at the time of the consultation. But I think what happened, there was this broadening, a lot more women kind of coming to it through these different groups, but there was also a marginalization of the more forthright, kind of clear position that we'd had earlier, because I remember having really futile arguments with some of these women in Facebook groups, because they were all still very much like, they wanted Hayton to be involved, they wanted Harrison to be involved, and Miranda Yardley, and all these kind of characters, and they would all absolutely, not all, a lot of them would fawn over these men and call them she. I mean, that, and if I objected, or if there was a number of us who would object to calling them she, and then basically that we were terrible, So it was interesting. There was definitely a broadening of the movement, big broadening of the movement, but at the same time, a lot of the women who are coming into it, and particularly those then who very quickly assumed, prominent positions with, I don't know, blogs and setting up groups and things like that, actually, I feel did not serve us well in terms of their language or their analysis. So, and we've seen
that's your thing, isn't it? The language. You've done some really good WDI.
It's really crucial, isn't it?
Absolutely.
And obviously, we, those of us here coming from a radical feminist background, we've got a radical feminist analysis. But even if you've got a basic common sense understanding of how language works, you don't use the language, all these fake terms, and all these fake pronouns adopted by the very movement that you're trying to resist and challenge. And you don't speak their language. And as soon as you speak their language, then you're doing their work for them. Even if you're arguing against it, you're accepting the terms, or their terms of what you can say.
The rules of engagement.
It's such an obvious thing that you don't have to be a radical feminist. That is just really, really obvious to me. But anyway, well, if we do any more of this, there were women who are now lesbians who are now involved in Lesbian Rights Alliance, Lynn Hahn and Elaine Hutton. There was a group of us who protested at a Dyke March, that was in 2014. A group of us who were handing out leaflets at Reclaim the Night, warning women about all these violent men who say they're women. And we were so attacked for that at the after party, the organisers of Reclaim the Night actually apologised to women there, for us giving out these leaflets, and then everyone kind of cheered when she said, "Oh, trans women are welcome here." So, and that was supposed to be, a feminist event, a women-only event with the radical feminist roots. So it's very interesting the shift that has happened. That's 10 years ago now. Anyway, we'll there's plenty more to say, but that's kind of a bit.
There always is. There always is. There's so much. There is so much. Need to write a book.
Well, actually, because there is a little bit of revisionism going on, I think, in some of the historical accounts. There's a little bit of amnesia going on. So maybe it is worth sort of putting a history together, I think. Because I think it's important for women to know where these ideas have come from and where the resistance has come from. Because if you block that, you block their access to very, very important ideas and, you know, very important history. Anyway, I'll leave it there.
On to our next section, I'm going to bring on Maureen to talk about our WDI UK's position moving forward and what we think in the UK we should be doing moving forward.
Tracy and I are both going to be talking about the WDI UK campaign, and it's involved. It's Northern Ireland and England, Scotland, and Wales are going to be involved in it, which we're calling "Restore Safeguarding, End Sex Falsification." And by ending sex falsification, we mean getting rid of all recognition of so-called gender identity in law and in practice. So that would involve changing the law, repealing the GRA, changing the Equality Act and the Northern Ireland equivalent, which relates to gender reassignment. And we're starting this campaign this year because it's the 20th anniversary of the Gender Recognition Act. It had nothing to do with the election being called. We didn't know the election was going to be called when we first started talking about this campaign. It's a coincidence. So we're wanting to end all forms of sex falsification in law and in practice. We don't think this is going to happen immediately, and I certainly don't think it's going to happen in the near future. But what we want to do is to widen the conversation, to raise the issue of ending sex falsification. And I think there are more and more people in the UK who are now starting to argue for that position, and we're hoping to extend that and create more public awareness of the impact of the different pieces of legislation and the practice as well that's going on. It's particularly in regard to the safeguarding of children, of women from sexual violence, for example, and of vulnerable adults as well, for example, adults who need same-sex care, intimate care. So we are planning to campaign around that in various ways, and I'm going to talk about the existing law. So a lot of you will already know about quite a lot of what I'm going to be talking about, I think, particularly in relation to the GRA, but I'm just going to cover it so that everyone's clear about it. And I'm also going to talk about the provisions in the Equality Act, which aren't quite so well known and haven't been so widely discussed in terms of possible repeal. So it's always been the position within the Declaration that there should be no recognition of so-called gender identity in law or in policy or in practice, that men cannot become women, and that the law shouldn't pretend that they can. Article 1 of the Declaration, and the Declaration is very much rooted in the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW. Article 3 of the CEDAW talks about taking appropriate measures to guarantee women the exercise and enjoyment of human rights and fundamental freedoms on a basis of equality with men. And we're saying that that has to include, and the Declaration says that has to include, the retention in law, policies and practice of the category of women to mean adult human female, the category of lesbian to mean an adult human female whose sexual orientation is towards other adult human females, and the category of mother to mean a female parent. And the exclusion of men who claim to have a female gender identity from these categories. That's a fundamental principle of the Declaration. And repeal of the GRA and the ending of other forms of legislation which promote gender identity follows on from that. So the law and policy that we're aiming to change, and we want to start debate about changing it, is the Gender Recognition Act 2004, which Sheila's already talked about. But we also want to remove the category of gender reassignment from Section 7 of the Equality Act 2010. That's one of 9 protected characteristics within the Equality Act. We'd like to see that removed because it's a form of recognition in law of the idea of gender identity and the idea that people can change sex or change gender. And the equivalent to that in Northern Ireland is the Sex Discrimination Northern Ireland Order 1976. And the provisions in that order are broadly similar to the Equality Act provisions. There's been less discussion about changing the Equality Act provisions in the UK than there has about repeal of the GRA. and it's also more controversial, even amongst women who advocate for sex-based rights, which I'll talk about a little bit. And we also want to remove de facto self-declaration of gender identity, which is happening in practice across the public and private sectors, and has been for many years, largely as a result of behind-the-scenes lobbying by gender identity organisations such as Stonewall and other organisations as well. But that existed even before that form of lobbying, because it's been possible for many years for people to change their sex markers on driving licence, for example, and passports. They can't change their birth certificates in that way, but they can change other sex markers, and that is a form, effectively, of self-identification or self-declaration of gender in practice. And it raises a lot of safeguarding concerns, because it allows people with criminal offences to more easily hide their identities. That's one of the things we want to change. So the key Gender Recognition Act provisions, which most of you probably know, it enables a person to get a gender recognition certificate, which will change their gender in law. Gender is used as a synonym for sex in law, and as Sheila's already discussed, there's never been any clarity about the difference between the two words. I suspect that was deliberate at the time. So they change their gender for most legal purposes, but not all legal purposes. And there are specific provisions in the Act which say that the Act will not have the effect in certain circumstances of changing someone's position in regard to their gender. One of which is Section 16, which is designed to allow men who are due to inherit peerages, so titles, to protect that. So if they have an older sister who gets a GRC saying that she's legally male for most purposes, she won't be legally male for the purposes of inheriting the peerage. The man will still inherit the peerage, which always goes to the oldest male in the family. So she won't become a fictional oldest male. He will still be the oldest male. So it's designed to protect a certain type of male privilege. That's one of the exceptions, which highlights, I think, how much of a fiction the Act is, and how much of a fiction the people introducing it really knew it was from the beginning. And to get a gender recognition certificate, a person must have a diagnosis of gender dysphoria. Sheila's already mentioned the medical professionals they have to have that has to be supported by, so I won't repeat that. They must have lived in the other gender for at least 2 years. That generally involves things like using a name that's associated with the opposite sex, dressing in ways that are typically associated with the opposite sex, and so on. And their application has to be accepted by a gender recognition panel, which consists of medical and legal professionals. They don't have to go in front of the panel if they don't meet the panel. It's all done on paper. So those are the criteria. And if they are seen as meeting those criteria, they will be given the certificate. They don't have to make any physical changes to their bodies at all. There's no requirement for that. That's one of the reasons why people who supported the legislation trumpet it as being very progressive, because it was the first piece of legislation in the world to do that, to allow people to change their sex or gender in law without any physical alteration to their bodies. So a member of the Penalist can get a gender recognition certificate very easily, and they often do. The protected characteristic of gender reassignment is contained in the Equality Act, as I said, and it applies to people who are proposing to undergo, are undergoing, or have undergone a process or part of a process for the purposes of reassigning their sex by changing physiological or other attributes of sex. No physiological changes are required, again. Protection on the basis of gender reassignment, which isn't the same thing as getting a gender recognition certificate, doesn't require a GRC. Equally, having this protection doesn't give a person the right to be treated as if they are the opposite sex in any particular circumstances. Although, because there's a lot of muddle about these two pieces of legislation, and there's a lot of confusion generated inevitably by creating a legal fiction that says people can change their gender or change their sex, many people believe that it does give them the right to be treated as if they are members of the opposite sex, and the pro-trans lobby groups have encouraged that. The purpose of this legislation is supposed to be protection from discrimination, for example, in employment and housing and the provision of different kinds of services, and also protection from harassment and victimisation. And it tends to, the cases that are brought under this act tend to be employment law cases, very many of them. So its purpose is protection from discrimination and harassment and victimisation. So one of the issues that's come up in the debate around the Equality Act provisions is the question of, if that's removed, how can people who identify as transgender, whether you may accept their subjective identification or not, how can they be protected from genuine discrimination and harassment? Not treating someone as if they're the member of the opposite sex is not discrimination under that legislation, at least not in theory. But there are situations in which they might genuinely be discriminated against, such as being refused housing, for example. There are types of discrimination in employment, but that's a difficult issue, which I'm going to come on to a little bit more in relation to autogynephilia. And also they can be victimised and harassed, genuinely victimised and harassed. So many people have argued, well, it wouldn't be right to remove the protection from discrimination and harassment and victimisation. But others have proposed alternative ways of protecting people who subjectively identify as transgender from those things. So, for example, Alexandra Astoriti, who's a legal academic, has suggested that people who identify as transgender could be protected under some of the other protected characteristics in the legislation. Those are sex, age, disability, race, sexual orientation, religion or belief, and marriage and civil partnership. She suggested that those who are or who are perceived to be homosexual could be protected under the sexual orientation characteristic, that those who have a diagnosis of gender dysphoria could be protected under the disability characteristic because it's effectively an illness, although that's disputed by the trans lobby. And also that identifying as transgender could be treated as the equivalent of a philosophical belief. The philosophical beliefs are protected. If that was done, that would frame gender identity as based on an individual's subjective belief, and other people would not be compelled to share in that belief or to behave as if they shared in that belief by, for example, using the pronouns that person preferred, or in other ways pretending that they believed that person was actually the opposite sex. So that would frame identification as being transgender as entirely subjective. That's one set of proposals that have been made. WDI UK isn't advocating for those. We're simply noting those proposals as one possible solution to the problem of how people who subjectively identify as transgender, who are genuinely being discriminated against or harassed or victimised, could still be protected if the characteristic of gender reassignment was removed from the legislation. So I already mentioned there are issues around autogynephilia, particularly in relation to employment. And developing alternative ways of protecting individuals who subjectively identify as transgender from discrimination and harassment would need to take account of the ways in which the manifestation of some people's beliefs about their gender identity, so-called, harms others and potentially undermines safeguarding. Many men who identify as women or say they do, as we know, are autogynephiles, which is a paraphilia. And a man who acts out of paraphilia in the presence of other people is a safeguarding risk, particularly in relation to children and vulnerable adults, and also in relation to women in many circumstances. So if we were going to look at alternative ways of protecting people who subjectively identify as transgender from discrimination in employment, for example, we'd have to look at how we can both restore safeguarding and think about how employment law and practice and recruitment practices should deal with the issue of autogynephilia. And that's something we haven't really even begun to discuss. Discussing autogynephilia at all is something that is very difficult because many trans activists and pro-trans activists deny that it exists. They do everything they can to shut down discussion of it. And although we raise it, and women who are advocating for sex-based rights raise it, we haven't really looked in depth yet at what the existence of autogynephilia and the effect on people who are around someone who is an autogynephile exhibiting their paraphilia has on those people, particularly vulnerable people, vulnerable adults and children, and how employment practices can deal with that. I don't think we've even begun to really look at that, but that's something we do need to look at. If we're going to argue that people who subjectively identify as transgender should be protected from discrimination, which I think we should. I think everyone should be protected from genuine discrimination. Then we need to look at what are the implications in relation to those who identify as transgender who are autogynephiles or who have other related paraphilias, which they are acting out or want to act out in public. Under the Equality Act, there are exemptions which allow men, including those who claim to be women, to be excluded from women's spaces and services if this exclusion pursues a legitimate aim and does so in a proportionate way. So the Act allows for the exclusion of males, or any males, from single-sex services like domestic abuse refuges, rape crisis centres and so on, although there's a debate about that. And there's been a push by the pro-trans lobby to argue that those who identify as transgender should be able to be included in what are single-sex spaces. But the Equality Act does allow for them to be excluded, including those with the GRC. So some feminists argue that we can protect women's sex-based rights by strengthening these exemptions in the Equality Act and clarifying the meaning of sex in the Act so that it's clear that it means sex and only sex and does not include gender or gender identity. And I think this could protect some sex-based rights more effectively than they can be protected at the moment, but it won't protect them completely. I'm going to talk about some of the reasons why briefly. So there are some rights which are conferred by a GRC which can't be limited by the Equality Act exemptions. One very obvious one is that a male prisoner who holds a GRC and is therefore treated as a woman for most legal purposes can generally only be intimately searched in prison by a female prison officer. If he can't be persuaded to be searched by a male, which sometimes they can be, but if he can't be, he will be searched by a woman. On the basis, and if the prison service tried to say, no, you must accept a search by a male, he would potentially have a claim under the European Convention on Human Rights, under Article 8, which is the right to respect for private and family life, and also under Article 3, which is the prohibition of inhuman and degrading treatment and torture. He could argue that it is inhuman and degrading treatment for him, a woman, as he claims, to be intimately searched by a male. Now, if a woman made that claim, that would be completely reasonable. And it would be inhuman and degrading treatment. A man who's treated as a woman for most legal purposes can also make that claim. And so women, prison officers, are searching male prisoners, many of whom are sex offenders, and many of whom retain male genitalia. And that includes intimate searches, which is arguably a breach of the Article 3 rights of those women, but certainly a breach of their Article 8 rights, their right to privacy. So that's one of the fundamental contradictions between sex-based rights and the ability of men to obtain a GRC. Also, as long as the law recognises or pretends that people can change their sex or their gender, whatever terminology is used, there's a potential for legal challenges to any exemptions that are introduced. And a very good example of this, something that happened in Canada to Vancouver rape relief. A former male client of theirs who identified as a woman, they did provide counselling services to trans identifying males, but they don't allow males, whether they identify as a woman or not, to provide counselling or other services to women as part of their service. Having gone through the counselling, he wanted to become a counsellor and they refused. So he took them to court, and eventually the case went as far as the Supreme Court in that particular part of Canada. And the Supreme Court said that Vancouver Rape Relief, in excluding males, all males, from providing services, were acting within the human rights law. So it was lawful for them to do that. That was a Supreme Court decision. But still, the trans lobbyists who were effectively trying to close them down if they wouldn't agree to allow males to provide counselling services to women, then started a campaign to persuade the local authority who funded the service to withdraw their funding, which the local authority did. So their funding was taken away. So the local authority was clearly captured by gender identity ideology. The activists involved in this campaign went on for years. They harassed Vancouver Rape Relief for years in different ways. So they got their funding cut, even though the Supreme Court had said what they were doing was lawful. Vancouver Rape Relief are still going, as far as I know. They certainly continued after that happened by fundraising and so on. But it's a very good example of the ways in which women-only services can be harassed and even potentially shut down, even though they're operating lawfully, as long as there's still a belief, a widespread belief, supported by law in whatever ways, that a person can change their sex or their gender, whichever terminology people want to use. So as long as gender reassignment or the possibility of acquiring a new gender, which is the language of the Gender Recognition Act, still exists in law, as long as that does exist, it's unpredictable what the effects of any exemptions which are designed to protect single-sex services will be. They can always be challenged, or can often be challenged, and lawyers will find ways of challenging them. So some feminists see keeping the gender reassignment provisions in the Equality Act, keeping some form of recognition of gender identity, whilst strengthening sex-based rights as a kind of balancing of rights. They see that as fair. But the legal recognition is a fiction, which is fundamentally incompatible with the sex-based rights of women and also with the safeguarding of women, of children, and of vulnerable adults. And the inclusion of men in the category of women in any form, I would argue, is not a legitimate right of those men and shouldn't be seen in that way, however they identify. It's an unjustifiable entitlement. So what they're doing is wanting not only to identify as women in their own minds, they're wanting to force everybody else to accept that identification is real and to act accordingly. They're wanting other people to deny their own perceptions of reality and conform with their perception of reality. They want women to do that, and they're also increasingly in schools, children are being forced to do that as well. So that entitlement erodes women's sex-based rights and girls' sex-based rights, undermines the safeguarding of women and children, and it undermines the safeguarding of vulnerable adults as well. I think that the existence of a so-called right in law for someone to be treated as if they had changed their sex is a fundamental contradiction in relation to protecting women their sex-based rights and to protecting sex-based rights across the board, and to safeguarding those who are vulnerable to predators. I just want to say something briefly about the Gender Recognition Act and the European Convention on Human Rights. The GRA was introduced after the case of Goodwin in the UK, which was a 2002 case in which the court found that the UK was in breach of Article 8, the right to private and family life, and Article 12 of the Convention. Article 12 is the right to marry and found a family. At that time, there was no single-sex marriage and no civil partnership. So Mr. Goodwin, or Christine Goodwin, as he called himself, could not marry his partner. They said that the UK was discriminating against, and they used this phrase, post-operative transsexuals. They said there should be a provision for post-operative transsexuals, and they're very specific about that, to change their gender in law. As Sheila's already said, people didn't talk about transgender in those days. Christine Goodwin had the operation. He was post-operative. When the legislation was introduced, it didn't require any operations to have taken place. Now, that was some time ago. Since then, the European Court of Human Rights decision-making has moved further and further in the direction of saying that member states of the European Convention are required to allow for some form of recognition of change of gender or change of sex in law. And in the 2022 case of AD and others against Georgia, the court stated that under Article 8, member states are expected to provide what they called quick, transparent and accessible procedures for changing the registered sex marker of transgender people. The court said that this is a positive obligation on states, and it has a very narrow margin of appreciation. What that means is margin of appreciation is something that exists to whereby the courts will allow some states a certain amount of leeway in the extent to which they comply with their decision-making, depending on their existing legal and cultural traditions. On some issues, there's a very wide margin of appreciation. Tax law is one of them. On some issues, there's a very, very narrow margin of appreciation, which means they won't allow for much diversion. And they said this was a case of a very narrow margin of appreciation. If the GRA was repealed, then that could be challenged in the European Court of Human Rights. It's likely, I think, the challenge would be upheld. And if it went that far, it's possible for the bodies of the European Court to expel a state, to remove a state from membership of the convention. They haven't done that very often. The only state they've done that to so far, to my knowledge, is the Russian Federation because of the invasion of Ukraine. So something very, very serious, but it's a possibility. And that raises issues and problems because for women, I think, because the European Convention has some important safeguards for women in relation to male violence, in particular Article 3, under which domestic abuse, for example, sexual violence are at the minimum inhuman and degrading treatment, and in some cases, such as sexual violence during warfare, defined as torture. So Article 3 provides important protections for women, and so do some aspects of the Article 8 decisions. So that would be a dilemma. But it's a very long way down the road. Thinking about Gender Recognition Act and thinking about gender identity more broadly may have changed a lot by the time any possible repeal came about. And I think we'd have to deal with that if it ever arose when we came to it. But I'm just noting that is an issue in regard to potential repeal of the Gender Recognition Act. Because now the concept of gender identity and the idea that changing gender is a right has become very, very deeply embedded in the thinking of the European Court of Human Rights. That's all I wanted to say. Thank you.
Tracy is WDI Northern Ireland contact.
Just add a wee bit of Northern Irish context for people outside of the UK. So Northern Ireland is part of the United Kingdom. We're also part of the landmass of Ireland, and we are caught in a pincer group between trans activists in the UK and those in the south of Ireland. So for example, there's a Transgender Equality Network Ireland that has been lobbying the Irish government. They've lobbied the Irish government more than Facebook. which is quite an achievement, given that Facebook's headquartered in Ireland for the EU. And they've also tried to lobby the Irish government to put pressure on the Northern Irish government to bring in explicit self-ID up here. So I have 1 foot in the UK and 1 foot in Ireland for this work. Ireland brought in the GRA in 2015. So that'll be a 10-year anniversary next year. So even though we're speaking about the UK context, we all need to be thinking about how gender laws were brought in our respective countries and have the same kind of goals of repealing all gender woo, getting gender out of law. So anybody who can hang around for the breakout rooms afterwards, it would be really good to get international conversation going. We also know that if we get gender laws repealed in one country, it then helps put pressure on other countries to follow suit. That's how gender recognition acts were brought in. It's a domino effect. On the way in, it needs to be a domino effect on the way out. So just keep that in mind while we're discussing UK specific stuff. In terms of a campaign, we're still very much planning the campaign. As Maureen said, we were starting to look at this before a general election was called. So Maureen and myself have been working on a document and we're still discussing some of these things. So for example, with the autogynephilia, am I, as a fellow employee, going to be accused of harassment if I refuse to engage with them outside of the bare minimum that I need to function to do my job? Could I be accused of harassment for being unfriendly or unkind? Or, you know, I want to feel that as a woman, I don't have to be made party to any type of fetish or to be party to any demeaning behaviour. And I see men presenting themselves as women as acting in a very dehumanizing way of women. So I think we've more to talk through there. Another concern would be that, you know, I don't think we should be developing policies specifically around autogynephilia. I think that at least in some settings where safer recruitment applies in the United Kingdom, if safer recruitment principles were already being understood and applied correctly, we wouldn't have men and women face in children's schools, for example. Any man who is using children, vulnerable adults, or even any other person as some kind of prop to validate his own fetish, and any man who's engaging in dangerous, escalating, clustering behaviours that are harmful should already be excluded from the ability to do that in the workplace. So I think what we have is primarily a crisis of safeguarding not being understood and applied correctly. I do recognise that outside of those school settings or in settings where we're talking about vulnerable populations, it is much harder to prove, for example, that a man is acting in service of his fetish by wearing certain things to the workplace. So I think that we need to, as part of this campaign, come up with arguments that make clear what we are protecting people from and what it should be protected against, and not get bogged down then in side discussions about, for example, gender presentation and clothing and that type of thing. So it's very much a work in progress that we are prioritising now that we've just had an election. And I know that we have a great deal of wonderful safeguarding expertise within WDI, and it's going to be very useful to draw on that for this campaign. So I was going to add that since 2019, I've been working with women and men in Northern Ireland on gathering and highlighting evidence of abuse and safeguarding failures due to transgender ideology here. And then I became the NI contact for WDI some years ago. As I've mentioned, we're in a situation where we've got cross-border pressure and we need to also be looking at repealing the Gender Recognition Act in Ireland as well. So alongside this WDI campaign, I'm also building a cross-border campaign group to look at that in the north and south of Ireland. And strategically, I do think it is useful to be fighting this fight on these multiple fronts, because if we can get some politician to take up the cause and speak publicly about it, we can leverage that against the others. And I think that applies with all of us within the global WDI movement. You know, we know that, for example, the outcome of court cases in America are going to be very useful to all of us everywhere else. Likewise, now we have court cases in the UK, and I'm talking about medical abuse court cases, by the way. I'm slightly concerned that some of our discrimination cases in the United Kingdom are focused on protecting a woman's right to have quote unquote gender critical beliefs. As we know, the problem isn't the definition of sex in law, it's the definition of gender. Everybody knows what sex is, nobody knows what gender is. Gender critical beliefs kind of perpetuates that problem in a way. And I think that we have been pushed down a side alley in some ways of playing the game of this false argument that there are rights to be balanced between safeguarding and privileges of primarily men to falsify their sex. I've only been in this fight 5 years. I owe a massive debt, like other people are saying in the chat, to all of you women who've been fighting this for much longer. But, 20 years after the GRA, and we've spent the last 5 years talking about balancing rights and that the GRA strikes a careful balance. 5 years, we've not been centering the safeguarding arguments. So every time I hear somebody say that repeal isn't possible, other people are saying it will take time, therefore we shouldn't even start. And that's what's really dangerous. I don't want us to be sitting 5 years down the line trying to undo the harm that's been done in the name of gender critical work, because the safeguarding issues have been ignored again, because whistleblowers have been silenced again. So I've been saying for some time that my biggest worry now is not trans activists, although given the Labour win yesterday, I'm slightly more concerned again. I'm more concerned about replication on the so-called GC side. I think, again, there are people with safeguarding expertise and experience, of which I'm not one. I'm a member of the public, trying to fulfil my duty as a member of the public to point out safeguarding issues where I see them and to get them looked at by those who do have expertise. And I think still those women are being silenced and excluded from the important work of undoing this harm. So I think that a solution is to make our focus a push to repeal these laws, and alongside that to call for a public inquiry, because it should not be on the shoulders of ordinary women to come up with solutions for all of these things. As I've said, and I've learned this from excellent organisations like Safe Schools Alliance and Keep Prison Single Sex, they understand safeguarding. They have been pointing out for years that compromises on safeguarding are failures of safeguarding, and that we must not enact further harm in trying to fix this. And Tanya at Safe Schools always says, kick it up the chain. And that's what I think helps a lot of us ordinary women who aren't working in frontline jobs where we're responsible for safeguarding. I think if safeguarding is everyone's responsibility, then potentially we need to be calling for safeguarding training for everyone, not just people who are in frontline jobs, but at the very least, those who are in frontline jobs, working in schools, working in prisons, working in psychiatric wards, hospitals. It's clear that there's been an absolute failure of safeguarding, and what we need is for the government to fully investigate that and bring to light all of the ways in which safeguarding has been destroyed. They need to admit that there has been a systemic safeguarding failure, and we need a non-statutory public inquiry which can move quickly and which doesn't preclude any criminal proceedings, by the way, because sometimes when we talk about this, people worry that a public inquiry would halt criminal proceedings, but it's the other way around. If a public inquiry is started and criminal proceedings are begun, it's the inquiry that will stop while the criminal proceedings are dealt with. So it is clear that people have failed children, vulnerable adults and women in the most awful ways, and those who have been responsible for such abuses do need to be held to account. We need to expose everything that has been done, learn from it, and then prevent it from happening again. That's the purpose of a public inquiry. It's to prevent these things from happening again. So I would encourage everyone, wherever you are, to go to Safe Schools Alliance's website, and maybe probably Liz Panton, who's the archiver extraordinaire, always in the chat providing the useful links, so no pressure, Liz. But if someone could share the link to Safe Schools template letter for MPs, that can be adapted wherever you are in the world. Let's start pushing politicians everywhere to call for a public inquiry into how this anti-safeguarding, anti-woman, abusive, homophobic ideology has been able to capture our schools, our hospitals, our public bodies, our regulatory bodies, our unions, our governments. It goes so far and so deep, and we need to begin the work of exposing the full extent of it. Now, on that front, we've got a wonderful resource in the WDI YouTube library. As you said earlier, Bernadette, it's been years now of running these FQTs, and we have had excellent, truly excellent presentations from people on the front lines of safeguarding work, and we have built this amazing library. We've also got Tish in the comments here. Still Tish on Twitter has done excellent work cataloguing and exposing the follow the money aspect of all of this. Jennifer Bilek doing the same in the States. Redux cataloguing the horrific stories of vulnerable women being abused by all of this. So we have done the work for the public inquiry team, whoever that will be, but we need to now call for it to be looked at in that systemic way, not just these individual testimonies of individual harm. It needs to be looked at as a complete systemic crisis of safeguarding enacted all throughout the Western world, and individual governments need to get to grips with that. So I think that's probably enough to say with this.